Aye.
Good afternoon. Thank you for joining. This is the top 10 things all property managers and board members need to know. My name is Jen Barnett. I apologize that we're a few minutes delayed we had a few technical errors. If anyone needs to leave, I know everybody's time is valuable. Um, my email is jbarnett, BARNETT, @meeb.com. Feel free to email me with any follow-up questions. Copies of our slide presentation will be made available after the webinar. Um, and I know we're going to go over a lot of material here today, so I will take as many questions as possible at the end, but let's try to get started. So today, we're going to cover common issues that every board member seems to be facing at some point or another. Uh, this is based on my 20 years of direct experience. We're going to talk about the most cited provisions of the Condominium Act, which is found in 183A section, and the best practices, what we can do to help uh, what we find to be the most efficient ways to govern and manage associations, and practice tips to avoid liability. Of course, there's no magic wand that we can wave, but hopefully this at the end of this they'll come away with some tips to avoid lawsuits and controversies. Starting out with common expense assessments. This is the lifeblood of the association, and I hate to use that phrase so casually, but that is the term that is often cited by Massachusetts courts when referring to common expense assessments. They are the lifeblood of the association, just as taxes and revenue are for a city or town. The associations in Massachusetts, we have myself and my colleagues have been successful in establishing the right for associations to assert multiple priority liens. And to do that, you can have what a priority lien is in the condominium context, at least in Massachusetts, is it's the 6 months of unpaid common area charges assessed pursuant to an annual budget or a supplement to the annual budget through such as a supplemental fee assessment. And it also includes the legal fees and costs related specifically to those charges. And it only covers a 6 month period of time. It does not include late fees, fines, interest, and other types of related charges. And the priority lien only is only established if the statutory framework is first met, and that requires notices, the recording, this commencement of an action, the recording of a complaint, and notice to the first mortgagees. The priority lien, if you do not act to every 6 months to follow the statutory framework, you risk the potential of losing out on a period of months, perhaps, in which those fees that are not paid are not entitled to priority. The mortgagees can avoid priority lien, which if they pay the amount of the priority, and that way they preserve their priority status over and above the rights of the association. Priority liens will not also include municipal charges for taxes, assessments, betterments. So that is just also something to be aware of. If there's no mortgage and no prior liens are on record, then it's the priority status is not so much at an issue, but it is still recommended that an association not wait to pursue delinquencies. If a unit owner is behind at least 60 days, they should refer the matter to council to start the collection process in order to preserve the association's rights. And as I mentioned before, the budget for the common expenses is a broad term, but for purposes of priority, they have to be assessed pursuant to an annual budget. They are supposed to be done in accordance and the assessed pursuant to the beneficial interest assigned in the master deed. So they should, so common expenses is, so if you have 100 units, oftentimes each unit is not going to have an equal percentage interest. So be wary and assess pursuant to the beneficial interest assigned in the master deed as amended. It would be recommended that an association have a written collection policy. For example, if an association could adopt a policy stating that they're going to apply any payments to the oldest outstanding balance. So if someone is challenging perhaps a late fee or fine, but continuing to pay their common expenses, if the payments are applied to the oldest outstanding balance, the monthly charges are going to arguably be entitled to priority, or the balance would be entitled to priority status. Similarly, special assessments for, say, unexpected snow removal, those would not be part of the priority. Therefore, we would recommend that the association consider adopting a supplement to the annual budget and then assess a supplemental fee rather than a special assessment to preserve those priority amounts. Also, be wary of board members who don't pay their common expenses. As a general rule, the rules, regulations, provisions of the governing documents should be applied uniformly and consistently across the board. And part of my pun, meaning that they should apply to everyone equally and no one should be excused from compliance. The board power and document amendments. So board powers are set out in the bylaws. And so those are typically contained within the declaration of trust, but they can also be found as an attachment to the master deed, and particularly in the older associations. The board has the power and authority to regulate typically the common elements. And so that would be everything outside of the unit. And so because the fundamental concept of condominium ownership is the individual unit owner owns the interior of their unit. The common areas are owned by all members of the association as tenants in common, and the board of the association is charged with the responsibility for maintaining and managing those common elements for the benefit of the entire association. So boards typically can regulate common area usage, parking, amenity use, conduct, guest policies, and they can do that oftentimes without unit owner consent. In some instances, I have seen documents that do require approval from the other members of the association for even rules, to adopt a rules, but that's unusual. But it's not. But again, you need to look to the documents because that is what specifies the board's power, responsibility, and obligations. The Declaration of Trust also spells out the obligations of the individual members of the association, and specifically the unit owners with regards to their conduct, their obligations to maintain their own unit, and the consequences for noncompliance. Unit owner approval is often required to amend the documents to expand perhaps the board's power and authority, or to grant if there was to prohibit smoking, that would require an amendment to the documents. The board cannot restrict a unit of smoking and ban smoking outright without an amendment to the governing documents. The amendment provisions are spelled out in the governing documents broadly and collectively. That is the Master Deed, Declaration of Trust, rules and regulations adopted pursuant to the Declaration of Trust, as and any amendments thereto. The amendments, you need unit owner consent in accordance with the percentages spelled out in the governing documents, and often you also need the mortgagee consent. Fortunately, in recent years, there's been an amendment to the Condominium Act allowing for a more swift means of obtaining that mortgagee consent, so it doesn't just go into a pool of where it could get lost if mortgagee consent's required. The association will submit the documents to the mortgagee. If the mortgagee doesn't respond, then within a set period of time, their consent is deemed granted. So, practical limits on the board's authority. You need to review before you act. You need to understand what the scope and limits are on the board's power, which again are spelled out in the Declaration of Trust. If you think of the master deed as as a playing board, that is what it's if you again. The playing board would be the master deed. So that is going to be your monopoly board. That is going to spell out exactly what parts and what is within the association in physical terms. The Declaration of Trust is the rules. And so that's going to say how you play the game. So the limited common areas, those are going to be defined in the master deed. But they may be outside of the board's general powers and responsibility to manage and control, and responsibility for maintenance, repair, replacement may be delegated to the individual unit owner who has the right of access to the limited common areas, especially whether it's an exclusive use area, such as a balcony, patio. Also, for any amendment to be recorded or to be enforceable, you're going to need to have it timely recorded. And some governing documents have different limitations. Some say within a year, some say within 6 months. It's important to look at what the governing documents provide. Also, if the condominium is built on registered land, that imposes even more strict requirements and must be filed for registration within a year. Otherwise, you need to start the entire process all over again. Also, in a registered land situation, oftentimes you need to obtain the approval from the land court to amend, and that needs to be factored in as well when going through this process. I'm sorry to be jumping so quickly through each of these topics. I just want to make sure that we have time to cover the salient points, and these are not by any means exhaustive of what the only issues that an association faces. These are just the highlights of the most common. Getting into the third issue that I often see is with respect to the transition from unit owner to developer control. This is when the developer has sold off the remaining of its units. Often it's at the expiration of their development rights, and at the time when they're about to divest themselves of their last remaining assets in the form of the units that they still own or control. So it's important that the association at this point start considering getting a unit owner controlled board, perhaps a transition committee in place to work with the developer if possible, and to understand what, if anything, is a potential issue following the transition event. look to the government, look to the books and records, make sure that you are obtaining that uh, the developer is paying common expenses on the units that they still own, from and that they have been paying from the time that the unit was phased in to the condominium through the date of any sale. Often we've seen situations in which a developer, the unit owner, a unit will exist for years, but the developer won't. But common expenses are not being paid by the developer while they retain ownership, and only when the unit is sold do common expenses start getting paid. The obligation to pay common expenses begins from the date that that unit exists, and regardless of whether or not it's still owned by the developer. So look to that. Also, when you're at the turnover, look to see whether or not the developer has been using common expenses to pay for developer related expenses such as infrastructure, or expenses that were deemed to be by the town or city to be within the scope of the developer's responsibilities. Finishing roadways is often a big ticket item for, and you want to make sure that the association has not been paying for developer related expenses. Uh, Also look at for make sure you have copies of all relevant documents. Make sure if there's any contracts in place, and if the developer, is the management company related to the developer? Is the developer using related or affiliated entities to perform landscaping, maintenance? Is there a means to terminate these contracts? These are all things that you want to know ahead of the turnover event, because once that turnover, the opportunity to take action and to seek redress is very limited. In Massachusetts, the limitations, there's a 6-year statute of repose, meaning that which begins to run from the date that the improvement is becomes put to use. So there might be different statute or opposed deadlines for phased condominiums, and which were done in different, so one was done in 2000 and one was done in 2010. There would be different statute of repose considerations. Within that 6-year statute of repose, there's also a 3-year statute of limitations that begins to run from the date that the association knows or has reason to know of a defect or deficiency. It's not, if the association knows in 2000 that there's a defect or deficiency but doesn't take action until 2009, or I'm sorry, 2006, that's outside of the 3-year statute of limitations, even though it's still within the 6-year statute of repose. So that is just something to be considered, as well as if there beyond this, the 3-year tort deadline for negligence claims. There's also a 4-year statute of limitations for breach of fiduciary duties. So if the developer, acting as a trustee of the association, acted in his own or her own best interest and against the interests of the association, without regard for, say, assessment and collection of common expenses, defects and deficiencies, there might be a way to avoid that knell of that 3-year statute of limitations and pursue a claim. It all depends on the specific facts and circumstances, though, of any case. At a minimum, I would suggest that if there is any suspicion of defects or deficiencies, that the association or transition committee, I should say, start to interview possible building envelope specialists, professional engineers, to determine what, if anything, needs to be done or corrected, what work is still left to be completed as part of the permitting, and whether there's any because there may still, if the project hasn't been completed and signed off on, there may still be a bond on file with the town. And even if the association of notice of following transition elects not to pursue a suit against the developer, it's information, that information is good to have for in terms of long-term budgeting and establishing uh, a calendar and a timeline as to when certain repairs need to be done and just a maintenance schedule. I know that there is some disagreement even among my firm as to whether what to do with that engineering report. If there is any inclination whatsoever that there is going to be litigation or if this is going to escalate into a dispute between the association and the developer, it is recommended that that engineering report not be shared with the developer or with the other unit owners, and that that the engineer work with counsel to maintain any privacy protection over that report. Oftentimes, that report is considered preliminary in nature, and it is done without the benefit of thorough and invasive investigations. So it is important that if they're not to um, give your opponent your hand and for purposes of just a litigation strategy. I would also make sure you consider hiring a CPA specializing in condominium accounting. Check to see that the developer paid all common expenses, and do not ensure that you're not signing any releases or waivers with the developer, even if, however accommodating or good the relationship was before. If the issue goes to litigation, that release could, even if it was even just to do a very small scope of work, it's possible that it could bar recovery for a much more expansive issue. So just be aware of that. If there's any questions, it is good to consult with an attorney at this time, and to get your team in place at the time of turnover. Just if, like I said, if nothing else, to help guide you through this process. As far as repairs versus improvements, this is also an issue that comes up often. So repairs are often thought of as fixing what's existing. Uh, a repair could a replacement of the siding with old vinyl siding with hardy plank or some sort of composite is not necessarily an improvement. There's not a very bright line definition, at least as far as the courts are concerned, as to what constitutes repair versus improvement. So you need to look at all of the circumstances. Cost alone is not determinative of whether or not something constitutes a repair versus an improvement. For example, an improvement could involve just something as simple as the installation of Zoom or video surveillance equipment or Ring cameras, because typically what an improvement, if just generally, is considered to be something that wasn't there previously. So this is the best example, or most common example, I should say, is a pool, fitness center, amenities, but it can also involve the removal of an amenity such as a tennis court, and it could be, and the paving over of it for parking. Under Section 18A of the Condominium Act, if 50% of unit owners are in favor of the improvement, or reverse improvement in the case of taking away an existing um, yes, facility or amenity, if 50% but less than 75% approve, then the cost of that improvement is going to be borne by the unit owner so agreeing. Under Section 18B, if 75% or more of the unit owners vote in favor of the improvement, then the cost is going to be shared amongst the unit owners as a common expense, again, assessed pursuant to their assigned beneficial interest. However, if the improvement cost in excess of 10% of the then value of the condominium, any unit owner dissenting from the improvement vote has an opportunity to petition a court where in the jurisdiction where the property is located, for an order compelling the association to purchase their unit for fair market value. And if approved, that purchase price would be shared amongst the unit owners as a common expense. Now, I will say this is if it is not an easy path to proceed in seeking this order. It would require the unit owner to obtain an expert to provide to offer expert opinion testimony on the value of the association as a whole and the purchase price of the unit. So it is not something that I would suggest that any unit owner dissenting rush into because to avoid paying for the improvement because the cost of litigation first it could exceed the amount in dispute depending on the value of the association or the value of their unit. And with any sort of litigation, the only thing that's predictable is that it's going to be costly and unpredictable. So it's be wary about it going down that path. Um, in terms of practical guidance, the board should document, you know, before taking on any improvement, look to the documents, look to see what the amendment provisions are, the process for improvements. Sometimes there's certain improvements that may require, depending on the documents, it is possible that if additional consent of first mortgagees is required. So look to the documents. The provisions of 183A are it's considered an enabling statute, meaning that the association's governing documents can be stricter, and therefore, if they're so make sure to look into your own documents when evaluating how to proceed. Also, I would recommend that the association not proceed without doing full due diligence to determine whether or not there's other options for proceeding with it. Voting mechanics. Now, voting comes up many times. It can come up with respect to voting on any amendment, improvement, as well as just determining who's going to be on the board. So look to see when the vote, especially with as board member voting, look to see when the annual meeting is expected to take place, what notice requirements need to be issued, and follow the notice provisions in the governing documents. Fortunately, the statute has been amended recently. Well, I shouldn't say in recent years, more accurately, to allow for electronic meetings and electronic voting. This allows for more. Ideally, allows for more unit owner participation, especially in communities that are more seasonal in nature, and it may be difficult to get many people in attendance live, either in person or by proxy. So with the dawn of electronic voting and electronic meetings, the idea would be that more people are able to participate for reaching the minimum quorum requirement. And so what that quorum is it's the minimum participation needed to have a valid vote or to have a valid meeting. If an annual meeting is called at which a quorum, the minimum number of participants do not attend, there can't be, no meeting business can be conducted. And if there isn't for example, and if there isn't a vote to elect a new board, then the existing board members will continue on to serve until their successors are elected or appointed in accordance with the governing documents. The also, when you're voting, you need to consider specifically what the documents say in terms of the measure of votes. Is it going to be by unit? And so is it the number of unit owners that are voting in favor, or is it the percentage of common interest? So, for example, in a 4 unit association, the units could be a majority of the unit owners voting in favor. Or if each unit owner is assigned, for example, 2 unit owners hold 75% of the beneficial interest and 2 hold the remaining 25. If the documents state that a percent, the beneficial interest is controlling then there is potential for the 2 units holding the majority of the beneficial interest to have their way in terms of voting. So be wary of those provisions. And election and removal. Um, Sometimes if the election provisions, this is where things can go awry. Especially if in a contested election, there is the potential for unit owners to challenge an election's validity if it is not done strictly in accordance with the governing documents. And this invites conflict in the form of rogue boards, and it can lead to escalated dispute and potentially protracted litigation. So follow the documents. There's many documents allow for proxy voting. Make sure you follow the proxy requirements. Make sure that the proxy ballot is signed. Make sure to designate a proxy. Oftentimes, the a proxy ballot will be signed without any designation as to who is supposed to who the proxy is being delegated to. Saying if there's no delegation, and then it's as if their vote doesn't count. In terms of appointment, to fill a vacancy, make sure you look towards those requirements as well. Sometimes the board members must be a member of the association. Sometimes there's a requirement that they be a member in good standing. So check to see what specifically the documents state as to who is eligible for election to the board. If the documents require that a unit owner, that someone be a unit owner, then the manager of an LLC outside for of an who doesn't own any interest in the association is not going to be eligible. Also, at the time, especially at the time of turnover, be wary if the developer is seeking to retain control of the board by appointing a slate of developer friendly trustees, because that is going to impact how the association proceeds in terms of taking any action necessary against the developer for defects, financial irregularities, etc. The removal of board members is an unpleasant task, but sometimes needs to be done if a board member is not fulfilling their fiduciary duty. And sometimes it can be done with or without cause. Often there's going to be a requirement to hold a meeting at which the board member at risk of being removed has an opportunity to appear and to object. Uh, Many times the board can vote without without the formality of a meeting, but as long as everyone is in consent to vote, that's not usually going to happen if there's a removal on an issue. So follow the documents. If a formal meeting is required, conduct the meeting so that there is not a later challenge to the removal. So insurance defense, this is where the topic gets dry. Thank you all for sticking with us this far. We're more than halfway through. And so insurance defense, happens when the association is sued. There's two types of coverage. There's what's known as a general liability. So that's your physical damage. It's typically a general liability policy is going to kick in if there's a slip and fall on snow and ice. And again, I'm staring out the window at however many feet of snow we have. So this is particularly relevant right now. Uh, the DNO, so versus a directors and officers coverage, that's known as a DNO policy, that is, it governs really board decision making. So if a board for example, if a board issues an assessment and it's later challenged, or a board takes action that is considered to be discriminatory, there may be coverage under a DNO policy. And with respect to coverage, once an issue or incident occurs, the association should alert the carrier. The carrier may pick up the defense and under what's called a reservation of rights, meaning that the association acknowledges that it has its defense obligations, but it is not, if it defends under a reservation of rights, that means that it is not agreeing to pay any judgment, and that it does reserve the right to withdraw coverage if it determines that there's no coverage for the claim under the policy. With a reservation of rights in Massachusetts, the insured and for all intents and purposes here, the board would be able to select its own choice of counsel, and the insurer would have to pay their reasonable rates. And with a reservation of rights, the association is in control of the defense. If the claim is defended without a reservation or under an indemnification, that means the insurer is control. The insurer then gets to select its own insurer, oftentimes panel counsel, and they control the defense of the claim. And the association has a duty of reasonable cooperation. So if the association may not want to settle, it's going to be ultimately up to the insurer to decide when the claim is defended under an indemnification or without a reservation of rights. The association or the insurer may deny coverage. That does not necessarily mean that that's the end of the road, and there may be a reason to challenge a coverage decision. Sometimes, not always. And so again, I would look to your attorney to help guide you through that process. The important thing, though, is not to delay. If a loss occurs, don't wait to report it, because that in and of itself may be grounds to deny coverage that may have otherwise existed. So we talked about the reservation of rights. As in terms of just tips, I would recommend that you know what the potential costs are going to be if there is a claim. A lot of times associations, especially if there's a long claim history, will have a much higher deductible, 25,000 plus, and it's becoming more and more common these days. So understand how it would be recommended for associations to consider amending the documents to require unit owners to maintain their own what's called HO6 policy, at least to cover the amount of the deductible, and also to consider adopting a insurance resolution as to how claims are going to be handled, and the application and division of the deductible for multiple claims. As poignant now, for example, ice dams. If there's multiple ice dams, how is the deductible going to be shared? Also, for all unit owners, I would recommend considering assessment coverage, so loss assessment coverage. So if an association has a claim that exceeds the amount of the insurance policy and then has to issue an assessment, loss assessment coverage may help cover that unit's portion of the assessment. My understanding is it's relatively short money, but if faced with a multi that you know tens of thousands of dollars in an assessment, it's a no-brainer. The other issue you want to consider is conducting an annual insurance review or I would say, if not more often, especially if the association has done any sort of large scale projects or improvements, because you want to make sure you have the adequate insurance for any loss or damage. I can recall a case in which an association suffered a fire, and it was catastrophic actually. And they discovered that were they lacked approximately $1 million in coverage for the damage. It was most of that that expense that was not covered was related to upgrades and due to code requirements and building code requirements, fire code requirements that that because the association had been built decades before. So make sure you are adequately insured by just working with your insurance broker. If and also many times that the associations require that if any unit owner has done improvements exceeding a certain threshold, oftentimes 5 or 10,000, that especially in an all-in policy, that that any improvements within a unit are also calculated into the amount of coverage, so that if in the event of a loss, the that's hard enough to work through, but add on to that the lack of adequate coverage to make the association whole, and the members who have suffered the loss whole, or at least as close to possible, is essential in these situations. So the I'm just seeing with respect to I just touched upon this in terms of handling the insurance claims. This is where a insurance resolution comes in particularly helpful. This outlines the process and procedure by which a unit owners should for but I would say for both the associate board members, property managers, and unit owners. It gives them for everyone a clear framework on how to handle these types of claims. And because they can get confusing, especially if at a smaller association where a unit owner may seek to submit a claim under the master policy without first seeking board approval, and it can lead to a lot of discord and strife if there's not a clear process. Oftentimes, the master policy is going to cover the common elements and the shell of the association. Contents and improvements that are unreported are not going to be part of the coverage under the master policy. The and you need to look to, is it a walls in or all in coverage? They have different meanings for purposes of insurance cover of claims handling. And if a unit owner is required to maintain an 806 policy covering their own unit, make sure that that is also in amounts adequate to cover the deductible. The other issue to consider is once a claim is filed, the association has a duty to cooperate, to provide information to the insurer. If oftentimes there's boilerplate language in the policy jacket stating that if the association or the insured rather does not cooperate, that gives the insurer grounds to deny the claim. And it's hard, like I said, it's hard enough to go through these issues without having to also fight with the insurer. So cooperate. Um, if in terms of if it's a catastrophic loss from a fire, from a flood, mitigate the damages, act as quickly as possible, work with your broker, to get an emergency remediation company in to mitigate the damages and prevent it from becoming even worse. The other issue to consider is if a claim is paid out, then to the insurance to the board as a trustee, obtain a release before releasing any monies under the claim. And because if the unit owner doesn't carry out with all the necessary repairs, the association doesn't want to be responsible for the any sort of consequences that might ensue. So if by obtaining a release, the association is turning over the funds to the unit owner of the damaged unit with the expectation that the work is going to be done by a professional, and that they are going to be responsible for performing the repairs, and upon demand they are going to have to provide evidence that the repairs were made, so that if, for example, they recover for an ice dam and claim the same damages in a year, they are going to be able to come forward and show that the prior damage was already repaired pursuant to the monies that they recovered under the claim. At the association, I would not recommend that if the damage is confined to a unit and doesn't implicate the common elements, then it would be a better practice to allow the unit owners to engage their own contractor to do the work rather than have the board manage and oversee. Because if something goes wrong, if the board is in that position, then it could arguably be liable for any actions or omissions by the contractor. So it's a better practice to avoid stepping into that role if possible. So getting into reasonable accommodations, this um, may come up particularly if if in a pet restricted community, a unit owner or resident may move in and with a dog. Rather than say dogs are not allowed if the person has a disability or uh, is believed to have a disability, then the association has to engage in an interactive dialogue to determine whether or not there's a reasonable accommodation. Emotional support animals are often the most frequent types of accommodations that are requested. It is not automatic though. The unit owner or resident still needs to um, provide the association, make a request to the association for the accommodation and provide the backup support. Oftentimes, simply a letter from their provider, does not have to be a doctor, but it does have to be their treating provider, stating that the connection between their disability, physical or mental, and their need to have the emotional support dog or other form of accommodation. The accommodation could also take the form if perhaps somebody is disabled physically and needs a different parking space. That might be something else that it needs to be considered by the association. If in smaller associations, um, the where it's if the accommodation request involves a modification to the common elements, depending on the size of the association, that cost may need to be borne by the owner requesting, but the board should still evaluate whether or not the accommodation is needed and the suitability. So if it's going to obstruct access, for example, a ramp is going to obstruct access to an emergency exit, that needs to be weighed against the accommodation. But if it can be allowed um, without too much uh, difficulty, then and there's not a real sufficient basis to deny it, perhaps then just beyond cost, the association really should consider whether or not to grant the request based on all attendant circumstances. It's it's difficult in these instances because the emotions can often run very high, and it's important not to let personal feelings get in the way of decision making. The a lot of times you boards fumble in terms of how much information can be requested. It's not all that needs to be provided is really a confirmation of the disability, and if you the board does not have a right to ask for the person's past medical records, and I would actually caution against doing so, because if whatever that is sensitive information, which if it falls into the wrong hands, could expose the board to additional liability for improper dissemination and failure to protect their privacy. So if you take one thing away before denying a request, just even if it seems ridiculous, consult with your attorney first and go through the process of allowing them to submit the requested documentation and allow the board to meaningfully consider the request and the proposed accommodation before acting. In terms of the next issue, and we're getting towards the end, thank you, is oftentimes with short-term rentals. And this may be more impactful in associations that have where there's a lot of tourists. For example, in Boston, there's many many units are used as short-term rentals on Airbnb and VRBO. The short-term rentals are regulated in the state of Massachusetts by the state, and they can also be regulated in the specific localities. That all presupposes, though, that these types of rentals are allowed under the documents. If the association documents prohibit rentals of less than 30 days, short-term rentals are not allowed, regardless of whether or not they may be allowed in that city or town or by the state. The issues that I most frequently see with respect to short-term rentals are with respect to the comings and goings of strangers in and out, the use and wear and tear on the common elements, particularly elevators. The lobbies can suffer damage just because of these rolly suitcases being dragged around. There's also the increase in trash, parking congestion. Sometimes there's a security concern because often the main door may be propped open. You don't, and if a lock is required, or if the code, obviously the other residents don't want that information shared with members outside of that community. There is also, depending on the frequency of the use of a property for short-term rental, it can convert a property or the characteristics of a property from residential to commercial use. And specifically in associations that are resident, can only be used for residential use, that might be a violation of the governing documents. And if to that point, if an association does not outright prohibit short-term rentals, but does prohibit commercial use, that may be a means of restricting that unit. It's not, every situation is different, but if the association is inundated with short-term rentals and if the issue is becoming more and more problematic, consider adopting an amendment outright, which would better regulate that the use of the units, and to prohibit the units from being used for these short-term transient purposes. Also be aware, going back to the insurance, that if a unit is being used to such a degree that for short-term rentals that it rises to the level of commercial use, that if there is a loss or damage, there may not be coverage if unless that there is commercial coverage for that unit because of that use. So even if the association is covered under a general policy and the claim may otherwise be covered, if a unit is being considered to be used for commercial purposes, and the policy only requires that it be used only for residential, and assumes that for purposes of issuing the coverage in the first instance, it may deny a claim for that reason alone. So just be aware. And so following up on fines and misconduct. So if there is a violation of the governing documents, the association has a number of tools at its disposal. First, if it does issue fines, it needs to be done in accordance, they're pursuant to the fine schedule if one is in existence. If there's not, fines should be reasonable. Fines are thought to be a deterrent. They're not supposed to be punitive, and meaning that if if the association is assessing $1,000 fine a day, for example, um, a relatively minor violation such as leaving the shoes out, it's going to be an uphill battle for the association if they wanted to pursue an action to recover those costs. As I mentioned previously, fines, late fees, uh, violate issue related to violations, they may be assessed against the unit. The assessment is constitutes a lien once it's applied to the account, which is the good news. But the bad news is that those charges are not going to be considered priority. This is may not be an issue if there's no mortgage or prior liens on the unit, but if the unit has a sizable mortgage, it needs that any costs or expenses related to the enforcement of the governing documents or as a result of a unit owner's or their family members' misconduct, that's going to be there's no guarantee that those amounts are going to be recovered, especially if the units are going to be underwater. Often this is most significant, and I find this to be the case, to be the biggest issue where there's a hoarding situation. And often if it gets to that level where where the unit is in such dire need of repair, replacement, it then before the association undertakes to resolve it on its own, and there it really should consider what alternatives are there. There may be alternatives if through the city, town, but don't rush to suit just because of a violation. See what ways there may be to resolve it without going to court, without the association incurring fees. We're here, and if it cannot be resolved outside of court, but in terms of just a practical approach, there's resources available locally and through the state that may help in situations, especially involving difficult owners who's who are violating the document, who are violating rules or are acting inconsistent with the governing documents because of some overlying or underlying issue that is beyond the board's control. So let's see. Jumping ahead, do's and don'ts. If just broad takeaways, follow the governing documents. Not all documents are the same. Uh, they are going and what is allowed in one might not be allowed in another set, even if the condominiums were created by the same developer. That does not necessarily mean that you're going to have identical documents. Comply with 183A if there's the any inconsistencies are going to be will be resolved by what's prevailing under 183A, except with respect to voting requirements. If there's a more stringent requirement set forth in the documents than there is in 183A, the documents are going to control in that instance. In terms of documenting decisions, some associations governing documents require meeting minutes. If meeting minutes are required, the association has to make those documents, those meeting minutes available by email. My recommendation is if the association does can keep minutes or is required to keep minutes, that they be as simple as possible. Document the date, time of the meeting, whether or not a quorum is present, identify whether it's a trustee or unit owner meeting, identify whether or not there's any votes and the outcome of the votes. Do not use the meeting minutes to do not include more information in those meeting minutes than necessary. Do not make reference to any specific unit owner if possible. Do not make reference to any pending litigation or strategy, because you have to consider that those meeting minutes are going to be available to any unit owner upon request. If the board is considering matters related to litigation or regarding collections, then my recommendation, go into executive meeting, and those meeting minutes should not be shared outside of the board. If a unit owner is seeking copies of the meeting minutes, make sure that the meeting minutes do not include any information regarding collections or lien enforcement, because that information is protected. It should not be disclosed. The and also try to avoid the inclination to transcribe what goes on at the meetings. It oftentimes will lead to debate, and the meeting minutes should be just as objective as possible, and simply they're to make sure that then at the next meeting a record of what was already done is present. It's not an opportunity, and it should not be viewed as a an opportunity to voice any specific gripes or grievances against any one individual or against a board member. And I would just avoid that if possible. As far as don'ts, don't allow one unit owner or board member to escape the consequences of a rule violation, and while treating another unit owner differently. If one unit owner is fined for leaving their shoes out, then the other and a board member who does the same thing should also be fined accordingly. The don't delay pursuing collection actions, because you risk losing the claim to priority to the extent one exists. Don't ignore the provisions of the governing documents if there are requirements to hold meetings and to follow certain protocols with respect to decisions or to improvements. Notice requirements, follow those provisions. Even in cases of a small association, I understand it's easy to do things informally until a dispute arises. Don't make private decisions outside of a meeting. If the documents require a meeting, the board should hold an open vote in that meeting, assuming that it's not related to issues related to litigation or held in an executive session. The transparency builds confidence, and if the association is kept informed as to the board's decision making and the reasoning behind it, it will help avoid or should help avoid disputes later on. And also, the board should act within the scope of its authority. If the documents require that a vote happen to amend the documents or to call a unit owner vote to even adopt a rule, follow that, even if it is another associations may delegate that responsibility to the board under its general powers and responsibility, stay within the scope of your authority. Also, be wary of individual board members acting on behalf of the entire association or behalf of the other members of the board, because in that capacity could potentially expose the board to liability. Also be careful of delegating responsibility to individual unit owners outside of the board. They would not be covered under the general indemnification provisions that often exist in the Declaration of Trust. And if they act outside the scope of their authority, by empowering them or knowingly allowing them to act in that capacity, they may be unwittingly exposing the association to liability. So we've gone a few minutes over. I apologize, and I apologize again for the late start. But if there are any questions,
Jen, we're here at the office and we've been looking at all the questions in the chat. I've tried to, there's a lot of people have the same one. So can I kind
yeah,
of steer you to a few of them by chance?
please.
Okay. So a couple people have asked about the responsibility of installing ramps and other things based on accommodation requests. And I know there's a change in the law. Can you just mention that briefly and talk to people about how to handle that?
All right. So the accommodation request, they if there's an accommodation request, the association has any request should evaluate the nature of the accommodation and the impact on the other members of the association. As I mentioned before, if the ramp, for example, is going to be block an exit or entrance, then is there another way to um, grant the accommodation in a different location? Just because it's requested, it doesn't necessarily mean that it has to be allowed if it's going to be detrimental, and taking into account all relevant factors. The cost, if it is, I believe it is less than 12 units, has to be can be assessed against the unit owner requesting. However, if it's going to be used, maintained by other members of the association, then it should be, if it's not going to be exclusive to that one unit owner, then it really should be a common expense. The other issue to consider is what happens after the unit owner leaves, is especially with respect to a permanent structure. If it's something permanent, then the board may decide that it's not to leave that open to the responsibility of that specific unit, um, but rather take on ownership and maintenance responsibilities and control over it as well. If any sort of modification, depending on the specific modification, if it's going to be an expansion of, for example, a walkway or it outside of one unit, then it may be, and only used by that one unit, it may be that the association wants to consider granting an easement to that unit, or so that if it would specify the duties and responsibilities for maintaining, repairing, etc. of that
On,
element.
okay. On improvements, there were a bunch of questions back on improvements, and someone asked, there's a bunch of similar ones. And if you were replacing something like a deck, a wooden deck with composite materials, is that an improvement or is that maintenance? Would that need a vote?
So it all depends. It depends if it's going to be on the same layout and framework. My argument, and you're not increasing the size. You're going to be building within the same footprint, and all that you're doing is replacing the the decking with a more suitable material. I would argue that that is not an improvement, but rather a repair. There is no bright line though on that issue, so it could still be open to debate. But just to improve an existing element simply because with a better suited material is not. I don't believe that that is a set that um, converts what would otherwise be a repair into an improvement.
Great. And is there anything boards can do to ensure that unit owners carry HO6 homeowners insurance policies, or what do we recommend boards consider doing?
So I touched upon this, and again, I apologize for how swiftly we went through every topic, but um, there are many associations do already require that associations maintain their own HO6 policies and the amount of the deductible. And in where that is required, the language will state that unit owners shall maintain HO6 coverage. The where it gets a little more tricky is when the documents say unit owners may maintain HO6 policies because it's discretionary in that instances. And to require the owners to maintain their own HO6 policies would require that an amendment to the governing documents.
Great. And the last one we'll take for now, and we will make these slides available to everyone on here, and the video will be uploaded in a link through our website. You talked about some statute of limitations. Can you just briefly mention about construction defect suits and claims against the builder or developer, how much time an association has and what those relevant timelines are again?
Sure. So with respect to any developer suit, the timeline is going to start to run from the date that the improvement becomes uh, as soon as the improvement becomes put to use for its intended purpose. So that would be usually we go by the date that this certificate of occupancy is issued. And again, they're in multi-phase condominiums. There might be different dates that for um, that timeline begins to run. With for construction defects, there's a 6-year statute of repose. Now that's going to be your outside window, and that starts from the date of the improvement being put to use, and running from that date 6 years out, unless otherwise told. But we don't need to get into that. Within that 6 years window, there or a 6 year statute of repose, there's other statutes of, for example, limitations. So the if somebody knows or suspects that there is a defect or deficiency um, in the work that was done, that from that first date that they know or have or reasonably should know, that's going to be the day one for purposes of a statute of the limitations are analysis. And so so that would be a negligence claim ordinarily. There's a 3-year statute of limitations for negligence claims. So going back, if the defect is apparent on day one, then that 3-year statute of limitations for bringing a claim under negligence is going to be 3 years from day one, even though the 6-year statute of repose is longer. There is a 4-year statute of limitations for breach of fiduciary duty claims. So, and those claims can be against the developer from related to his actions or inactions as while a trustee in control of the association. Uh, and that may, and so for example, if the association of unit owners is not in a position to take action um, within the 3-year statute of limitations because the developer retains control over the association um, beyond the limitations set forth in the documents, there still may be a remedy to recover potentially because arguably the developer did not take action against himself to correct these defects and deficiencies, knowing of them, and in doing so he put his own or her own interests ahead of the association in breach of their fiduciary duties. And but that's it all is fact dependent, and there's no guarantee that if the 3-year statute of limitations um, is not is expires, that there's still going to be a means for recovery. However, there is a 6-year statute of limitations for contract actions, And in certain cases, there may be an opportunity to pursue a claim against a design professional, such as an architect or engineer, who was involved in the building process of the condominium, under a theory of third party, as a third party beneficiary. It's not an easy claim to prevail on, but it can be accomplished if you are able to demonstrate that the individual or company that provided services ultimately knew that the association, that the work that they were providing and the services that they were providing were intended for the benefit of the association at the end of the day, and therefore had a duty under the contract to ensure that the work was done in accordance with the plans, the documents, code, law, ordinances, how whatever the issue is, and that's being alleged to have been breached. But
Thank,
co- factual dependent.
Jen, thanks so much. Everyone else who had some questions that may have been unanswered, please feel free to email them to jbarnett@meeb.com or info@meeb.com. Reach out to Jen if you haven't received the slides that you've requested. If you have any other questions, Jen, we really thank you for your time, and everyone, we thank you for joining us.
Thank you.